Sir, I begin by sharing the sentiments of Mr. Mahipal, the Honorable Member, insofar as he underscores the importance of local democracy and the important role that local democracy must play in the administration of our country's affairs. And it is from that backdrop, Mr. Speaker, that the act which my friend seeks leave of this House to amend was crafted. And Mr. Speaker, perhaps I should begin by reciting the historical evolution of the act itself so that we appreciate the road that the act has traveled and to appreciate why what is stated in the act must not be lightly interfered with. Sir, you have been in politics a long time, and you remember the 1997 general and regional elections, the violence and public disorder which resulted therefrom, and the appointment of the three wise men by CARICOM, as well as the establishment of the Hermanston Accord and the diminution of the PPP's government tenure from a period of 5 years to 3 years. All of that was done to move into certain reforms of our governance structure through a constitutional reform process. And that process was embarked upon with the philosophical underpinning and thematic intention to reduce powers that were then concentrated in the executive and to devolve those powers into other organs of state, including this Honorable House, the local government structure, the leader of the opposition, and many other important state agencies in our constitutional apparatus. That was the focus of the reform. So my friend is perfectly correct, because an important and a fundamental segment and direction of those reforms was to empower local organs. In fact, one of the mischief identified was the overriding power of the local government minister. And the question arose, where should that power be residing? We had complaints about ministers suspending elected neighborhood councils and establishing as a substitute, therefore, interim management committees. That was found to be undesirable. And a whole host of plenitude of ministerial powers were found objectionable. So, where should we reside those powers? And it was decided as a matter of policy that those powers must reside in a local government commission, which must be elevated to a constitutional status. And that commission must have as its most fundamental characteristic its autonomy and independence as a commission. And that is why it was elevated to a constitutional commission, because constitutional commission are endowed by the Constitution with a repertoire of independence and autonomy by the Constitution itself without the need for enabling legislation. So, Mr. Speaker, out of that context, Article 178, Article 78A was born. And this is what it says, Mr. Speaker. It says, Mr. Speaker, Parliament shall establish a local government commission, and this was since 2001. Parliament shall establish a local government commission, the composition and rules of which empower the commission to deal with, as it deems fit. The independence is ensconced and entrenched, must deal with matters as it deems fit. I pause here again, not upon the advice or after consultation with anyone or any authority or any agency. The drafters of the Constitution, had they had such an intention, could have easily inserted that phraseology to consult as they deem necessary. But the Constitutional Reform Commission, which was a bipartisan commission, resolved, I will deal with Article 13. I will deal with Article 13. The Constitutional Reform Commission crafted this language as it deems fit. All matters related to regulation and staffing of local government organs and with dispute resolution within the local government organs. So as it deems fit, lawyers would know, means the widest of discretion, the most untrammeled discretion, only with legal limits, that these discretions can be absolute so as to become abusive. So once the legislator legislates the term as it deems fit, or in his opinion, or in the exercise of his deliberate judgment, it is the intent of the legislation and the legislator to endow the decision maker with that power and not make it subject to the input of another. And that is what the Constitution, our supreme law, has endowed the local government commission with. And Mr. Speaker, out of that came the Local Government Commission Act. And Mr. Speaker, the Local Government Commission Act had a particular history as well. From 2001, it did not reach the National Assembly until 2013. You had a governmental task force established again between the PNC and the PPP to trash out a whole regime of local government bills, of which this was only one. And they took from 2001 until 2013 until they produced the Local Government Commission Act. And Mr. Speaker, when the act was being debated, and I want to go to the debate, you see, an important principle of lawmaking, Mr. Speaker, an important principle of lawmaking is that we must ensure that we make laws when we have the power to do so. We make laws of the quality and type that we must be able to endure and be comfortable with when we don't have that power. So in 2013, Mr. Speaker, we had a minority government. The PPP was a minority government. And the record of this assembly will palpably demonstrate that only bills that found support of the then one-seat majority opposition were able to pass. The record of this assembly will record how many nationally important bills were rejected and projects putting us in international problems and in economic problems locally. We got a judgment from the CCJ in the Rhodesia matter in the sum of $6 million US because we were unable to get your support to amend the Customs Act, and that cost us $6 million US dollars. Then the series of AML-CFT bills, we were unable to get your support, as a result of which we were blacklisted. We were unable to get your support on a number of projects in budgets, and they were all slashed. Amila Falls, Specialty Hospital, Amerindian Development Projects, and I can go on. The point I want to make emphatically, that was a parliament that could only have approved that which you approved. And you approved this act that you now want to amend. And I want to make that point. What you approve when you have the power to approve, you must be able to live with it when you don't have that power. That is the fundamental point I want to make. And to his credit, Minister Bull, the then member, listen to the Honorable Member Ronald Bulkan, who detailed the history of this bill. Mr. Speaker, I invite your attention specifically, your undivided attention, to describe the travail and journey of this bill. Listen to Mr. Bulkan, the Honorable Member. He said for the majority of this House to have agreed to such a proposal, sorry, let me get to Bulkan himself. Oh, this is it. Sorry. He said, he was speaking of the bill, it being worked on since 2001, and this is what he said. Even if we take the period from December 2001, when the Joint Task Force was commissioned, to now, is a period of 140 months. 140 months. And now you want to come and change it just like that? 140 months we labored. And listen to how Bulkan described it, the Honorable Member then. The gestation period, which is the period from fertilization to birth, we are all aware that in the case of humans, it is 9 months. In the case of a donkey, it is 12 months. In the case of a goat, it is 5 months. In the case of a whale, varies between 16 to 20 months. And for an elephant, it is 20 months. So in this period, we could have brought forward 15 cycles of humans, 11 cycles of donkeys, 28 cycles of goats, and it goes on. with that biological evolution cycle, how can we revisit this after a couple of months? Look how much animals were born during the period that took to birth this bill. And Mr. Mahipal invites us flippantly this morning.
Words of the leader of the opposition, a whole menagerie.
And Mr. Mahipal invites us almost summarily to reconsider this bill and change it. We're not going to do that, Mr. Mahipal. Too many donkeys were born in the process. We can't insult. We can't insult the animal kingdom like that. But more importantly, Mr. Speaker, in the select committee, this matter although the bill spent so much time in its preparatory stage, when it reached the floor of the National Assembly, it went into a select committee. A select committee that you took the majority of, historically, creating history, and a select committee, a bill from the government, you took chairmanship of that select committee, not the minister. Every select committee, I know you are the majority, so that's why I'm detailing it, to understand the control that you had, to understand the intent,
Control freakism.
the intent that you imparted in the terms of this bill. So, Mr. Speaker, they took the not only majority in the committee, but they took the chairmanship of the committee
If that is not
and invested that responsibility in that man of legendary competence, the Honorable then Basil Williams. And he presided over that committee, Mr. Speaker. So nothing could have passed muster there. And you know what? There is karmic forces operating. You know, the select committee went, the bill from the government went to the select committee with provisions to broaden the discretion of the commission, to give it a little more teeth. And you know what the policy position of the opposition? No, the commission's autonomy and independence must not be interfered with at all. Today they come to interfere with and dilute their very independence. That is it. I have the Hansard in front of me.
Read it, read it.
It says that the commission must remain autonomous. Section 13 was specifically considered. Section 13 was specifically considered. And Mr. Bulkan said that the commission must remain true to its constitutional parameters. Not that he could have said anything different, because the Constitution is the supreme law, as I will demonstrate at the second stage of my argument. So, Mr. Speaker, the point I want to make is that in the committee and in the case, in the bill, in the debate, the Honorable then Prime Minister Moses Dangamutu also emphasized the need for an autonomous commission, that the commission must function in accordance with the spirit that it was imbued with by the Constitution. So, Mr. Speaker, to make it even abundantly clear, or even clearer, the bill, which it did not have to do, enacted Section 3. And the bill, to further send that clear message that the bill, the commission, must remain independent and must make its decision as it deems fit, to ensure that that plenitude of power given to it by the Constitution remains intact. This Parliament, when it passed the bill, re-registered what the Constitution emphasized. We have to follow the Constitution. We don't have a jurisdiction to depart, but Parliament overemphasized it by putting it back again in the legislation in Section 3, which says, in the exercise of its functions, whether the functions are recruiting staff, whether the functions are disciplining staff, whether the functions are overseeing the work of the Neighborhood Democratic Council and the local democratic organs, whenever it is exercising those functions, the commission shall not be the subject to direction or control of any authority. And that is in keeping with the language. This was not necessary. This is redundant. But this House re-registered its pure position that no departure from the Constitution on this matter. In other words, it made it extra and crystalline on the issue. So, Mr. Speaker, but this bill didn't have to say that, because the Constitution, as I said earlier, endows all constitutional commission with a similar power. Mr. Mahipal, listen to me. 226(1), Mr. Speaker, of the Constitution, Article 226(1) of the Constitution, our supreme law says this: save as otherwise provided in this Constitution, in the exercise of its functions under this Constitution, a commission, of which the local government commission is one, shall not be subject to the direction or control of any other person or authority. So the Constitution itself prevents any dilution of that independence. So we didn't need Section 3 of the Act, because in any event, Section 3 of the Act, had it conflict with the Constitution, would have been unconstitutional. So it is intra vires the Constitution, and the Constitution itself reinforces at Article 226 that one can't depart from one can't derogate, rather, from the independence which constitutional bodies are endowed with. But, Mr. Speaker, I am not going to leave the matter there, because this matter also received judicial interpretation. So, Mr. Speaker, I heard the honorable member spoke about how we should interpret the articles of the Constitution, and not to detract or in any way to cast aspersions on his demonstrable ability to interpret constitutions. We have an agency authorized by the state, by our Constitution, called the Judiciary, and they have the conclusive authority to pronounce on interpretation of any provisions of any law we pass, including the Constitution. So the judiciary, as the authorized agency, has pronounced upon the provisions of the Constitution. The Constitution allows for criticism and appeal from judicial decisions. So this decision, as you have me on appeal, was not appealed. So this remains the conclusive pronouncement from the judiciary on the matter. And it is the judgment of the Honorable Madam Justice Joanne Barlow in the case of the town clerk of Georgetown against the Local Government Commission, 2021 High Court, Demerara, Civil, SOC 2026. That's the case name, case number assigned to the case. So in this case, the functions of the Local Government Commission came under judicial review. And I will not detain you unnecessarily by going through the entirety of the judgment. I will select the relevant parts and I will distribute the judgment for your record, Mr. Mahipal. So one of the contentions identified by the court as the issues at third page of the judgment, and is highlighted when it comes to you, you will see it highlighted in yellow, was the defendant, the local government commission, under a duty to consult with the municipality before arriving at a decision? Was there a duty to consult? That's the very question you want us to offend the Constitution by inserting in the provision that you're seeking, right? You want us to offend the Constitution in its current form because the Constitution says this commission must act as it sees fit. You want the commission to consult. That's the very issue that's before the court. Let me pause here to say,
consult, recommend.
And recommend. You're going even a step further. Consultation is a desirable concept. Let me say that. Consultation in the political realm and the realm of administration is obviously desirable. And everyone should consult. Everyone should consult. So the judge, after reading the provisions of the Constitution, Article 78A, and emphasizing the words deem fit, the judge, in her ruling on the issue, and I'll go straight to that issue, as expected, the judge paid great recognition to the concept of consultations and said that it is good for good administration, it's good for governance, it's good for accountability and transparency. All that the judge did. And then the judge concluded the matter this way. In the case of the commission, this is what the judge said. I'm reading verbatim from paragraph 27, after highlighting the importance of consultation. In the case of the commission, consultation must be what the Constitution in its own deliberate judgment determines that it needs. In the absence of a legal duty to do so, no practice or expectation can oblige the Commission to consult with any entity that it must regulate. If it decides to do so, it has the power to do so, because it can make decisions as it deems fit. So there is nothing stopping the commission from consulting, but if you make it an obligation to consult, then you are running afoul with the freedom that they have not to consult. And that is what deems fit means in the circumstances. They have a power to consult, perhaps they have a duty to consult, but the Constitutional invested them with the latitudinal freedom also to not consult. And you can't take that away from them. Only the Constitution can take it away from them. You are a member of the Constitutional Reform Committee, and when we begin to work, you can amend Article 78A. But your legislative attempt here cannot achieve that objective. And Mr. Speaker, there is still yet another court order that I want to make reference to, because my friend, again, in exercising, as I said, his well-known ability to read and interpret the Constitution, he sought to explain to us the important canons of constitutional interpretation, and that we must read the provisions in harmony so that they make sense, that one can depart from the other. And I recognize that, and I salute you for that outstanding legal principle. Now that very issue, the issues of these very provisions and the apparent conflict to which you advert, were also the subject of court proceedings. This time the mayor and councillors of the city of Georgetown against the Attorney General and the Local Government Commission. Action number 2022, High Court Demerara, Civ FDA fixed date application number 294. This was a case where they went to court and they did the same thing. They asked the court to rule that one provision of the Constitution conflicted with others. And among the same thing that they asked, a declaration that Article 75 of the Constitution of Guyana is the leading provision and should prevail over Article 78A of the Constitution, the very argument that you have advanced. A declaration that Article 78A of the Constitution is inconsistent with Article 12 of the Constitution. A declaration that Article 78A of the Constitution is inconsistent with Article 71 and 74 of the Constitution. So Article 78 came under severe scrutiny. It was a focal point of the attack because, like you, there was some inference that it collided with the rest of the articles. And there's a whole page of declarations that the court were invited to consider. And the court ruled, unfortunately, the judge, Justice Navindra Singh, did not deliver a written judgment, but I have the court order. Having recited everything that were asked for by the applicants, the Georgetown Mayor and City Council, the court orders, and I'll distribute this too, the court orders that this application be and is hereby dismissed with cost to the first name respondent, the Attorney General, in the sum of $200,000 and cost to the second name respondent in the sum of $50,000. So, Mr. Speaker, not only have I demonstrated politically that when it was the opposition's turn, this is the bill, which is the current act that they brought to this House. And I have the Hansard of the debates, which I can circulate, and you will see, sir, the several places in the Hansard debates where they emphasized that they want this commission to act independently and autonomously, in keeping, and rightfully so, within the spirit and letter of Article 78A. And that is why they fashioned the bill as they had the controlling vote in the House, in the manner in which they did. And then, Mr. Speaker, it is also APNU-AFC that brought the bill into force by an order of Mr. Bulkan, dated 23rd of October 2017. And the bill passed in 2015. So if they had any misgiving...
And Honorable AG, you will have to get an extension.
Mr. Speaker, I would like to ask for an extension to my colleague to allow him to conclude his presentation in accordance with his standing orders. I think 38, I may have got the wrong number.
So, Mr. Speaker, while in opposition they passed it, then while in government they had an opportunity to change it in the manner that Mr. Mahi Paul, the honorable member, now recommends. But rather than do that, they brought it into force. They brought it into force by an order of Mr. Bulkan, and they appointed the commission in its current construct and stood by it until the people of Guyana bid them goodbye at the March 2nd elections. You didn't see fit to change it. What you were comfortable with in government, you must be comfortable with in opposition. That's a political lesson. And the legal lesson that you must bring laws that are consistent with and in compliance with the Constitution, because the article of the Constitution, the supremacy clause of the Constitution says very clearly that any law that is inconsistent with the Constitution would be unconstitutional, null, void, and of no effect. Mr. Speaker, the bill that the honorable member is seeking leave to put before us runs patently and manifestly on a collision course with our Constitution. Let me recite a case that all of us know, the case of Ali and Jagdeo that went to the Caribbean Court of Justice, when the chief elections officer sought to denounce 172,000 votes. And one of the challenges that were before the court were whether Order 60, which authorized the recount, which was a subsidiary legislation, which GCOM was empowered to make in certain circumstances, they argued that that Order 60 was inconsistent with the Constitution. And through the mouth of the President of the court, the Honorable Justice Saunders, he said, any law, moreover, subsidiary legislation, which is or are in tension with the Constitution, would be void to the extent of that tension. Insofar as this bill seeks to circumscribe the powers of the Commission, as benevolent and benign as it may appear to be, once it seeks to circumscribe that power that the Commission has in its decision making, whether to require it to consult as a matter of law, or worse yet, to act upon recommendation of some external and extrinsic agency, that will run afoul of Article 78 of the Constitution that invests in the local government commission the power to make decisions as it sees fit. Mr. Speaker, with those few remarks, I ask this Honorable House to refuse leave to the Honorable Member to proceed any further with this matter. Thank you very much.
Thank you very much, AG.